Select Committee. I'm looking forward to the deliberations and to the submissions we will receive on it. I commend it to the House.
The Honourable Phil Goff.
Mr Speaker, as my colleague Andrew Little said, Labor will be supporting this bill through to the Select Committee, notwithstanding the fact that it was an election promise and therefore some may be sceptical about the motivation of it. I think there is a need to reflect on the fact that there is a small group of people in the community who are very likely to re-offend. One of the hardest things that I found in 6 years as Minister of Justice was dealing with people, particularly people who were often of low intellectual ability. They were most frequently pedophiles. They behaved in a way that to all of us in this House would be totally irrational. They were compulsive in their behaviour, and I worried a lot about some of those individuals. I can still think of the names of some of them that were released publicly, Lloyd McIntosh being one of them, who was responsible for sexual violation of a baby. It's not normal behaviour. He had low intellectual disability. He had served his time. We couldn't do anything with him. And it was that particular case that led me to think very seriously about what we do in that minority of cases where people who have served their time and would normally be released to the community aren't actually safe to have in the community. And we did a range of different things, Mr Speaker, all of which were effective to deal with most of the cases that we confronted. One was to actually say, rather than sentencing somebody effectively after they'd already served their time, was to make greater use of the offence of preventive detention. As you're aware, Mr Speaker, preventive detention means that when you're sentenced under that for usually a serious sexual or violent offence, you can be detained indefinitely. You are only released when the professionals consider you are safe to be released, and once you are released, you can be recalled at any time that you show high-risk factors that you are likely to re-offend. So we extended the use of preventive detention so that we could deal with that category of people who, for reasons that in some senses they were barely culpable for, because they were, as I mentioned before, of low intellectual ability and compulsive behaviour, the community had to be kept safe from them. With the case of people that are sentenced to life imprisonment, which is a restricted number of offences, of course, such as murder, again, when you release people, you have the capability to recall them if they look at risk of re-offending. But that doesn't cover the sort of people that we were concerned about. Normally, when somebody has served their sentence right to the end, you can detain them for 6 months past the period of their determinate sentence. But again, some of these people clearly weren't safe to be in the community. There is the Intellectual Disability Act, and that gives the authorities the power to detain people for up to 3 years. But I accept that notwithstanding the range of things that we put in place, there is still a number of people, said in the regulatory impact statement to be between 5 and 12 over a 10-year period, that fall through the cracks, that aren't even adequately dealt with through the system of extended supervision that can last for 10 years, which was perhaps the most effective measure that I introduced to try to deal with people that were very high-risk re-offenders and re-offenders in terms of serious offences that had dramatically bad impacts on their victims. So I accept that this bill is not about punishment, it's actually about protecting the community. And protection of the community in these small number of cases is a valid consideration against which to balance the principle, the long-standing principle of justice that you do the crime, you serve the time, and when you've served the time, you're released. You're a free person. What we're actually proposing in this is to say when people have served the time, actually they will keep on serving time indefinitely. And that is a significant step to take. Most countries have indeterminate sentences such as preventive detention. That meets the criteria of the United Nations Human Rights Committee. It meets the criteria followed by the European Human Rights Court. But the concept of detaining people after they have served the sentence imposed on by the court is pretty unusual. We can be pretty certain that it will breach the New Zealand Bill of Rights Act. We can be pretty certain that it breaches the International Covenant on Civil and Political Rights. So you don't take action, you don't legislate in a way when you know in advance that you're going to be in breach of significant pieces of legislation and international obligations. When I've looked internationally at what's done, actually there's not that much that goes this far internationally. In some of the Australian states, people can continue to be kept in prison mainly for crimes of sexual offending and often sexual offending against children. In the United Kingdom and in Scotland, in England and in Scotland I should say, there is a form of close supervision for sexual and violent offenders, but that is in the community. In the United States there's a form of civil detention. So we are taking a very significant step here, which is why the Select Committee will be obligated to look very closely at what this bill actually means. I accept that there are safeguards put into this legislation quite appropriately. There will be regular reviews of detention by a review panel and by the High Court. There will be an independent inspector. There will be ombudsman's visits, and there will be annual reporting to Parliament. But notwithstanding all of those things, this is a pretty dramatic step to take. The objective as set out in the regulatory impact statement is to deal with people who present and I want to quote it, a very high risk of imminent and serious sexual and violent reoffending. What does that mean? Well, very high risk means that offending is considered to be extremely likely, and the judgment will be made by professionals such as psychologists who have worked with the individuals over a significant period of time. Serious means that you're actually, if you put this small group of people out into the community, you are putting individuals at risk of really serious physical and psychological harm. People who are innocent victims, and you don't really want to have those people victimised before you take a step that may be almost inevitable of waiting for an offender to offend and then putting them away. The damage has been done. Imminent is also an important word. It means that offending is expected to occur when, provided with a suitable opportunity, the offender would immediately inflict serious harm on a vulnerable victim. When you consider those criteria, you consider that the people that you are dealing with are a real problem to the community, and there needs to be a way to protect the community from those individuals. Mr. Speaker, I've talked about international practice and looking at the regulatory impact statement. It is difficult to find a lot of precedents for what the House is being proposed with, so I think the Select Committee, if it decides to proceed with this legislation, will need to ensure that the safeguards are very clear and are very reliable. The final thing in terms of human rights, if I want to come back to that, is to say that the regulatory impact statement does make it clear that this will breach human rights legislation in this country and internationally in a number of different ways. The challenge that we will face in examining this legislation, first of all the Select Committee examining it and then us in the House, is to ensure that any action that we are taking can be justified on the basis of an intense risk from a very small number of people, and on that basis the Select Committee and the House may subsequently find that this legislation does need to be put into place.
I call David Clendon.
Thank you, Mr. Speaker. I think it's interesting that we're debating this bill for the first time in Parliament 1 day short of a year after its introduction. It was introduced on the 18th.